Hey, it's What's Up Wednesday with James, and today I'm going to talk to you a little bit about the purchase and sales agreement, specifically about earnest money. Actually, a few days ago, I got an email from one of my agents asking me to share some information specifically about item number 6 and 7 on the purchase and sales agreement, which is our Form 201. So let's go ahead and just dive right on into that. At the end of the day, you have to have earnest money. It's not required by law, but it's good faith that the earnest money is put up front by the buyer so that the buyer is indeed showing good faith to want to move forward and purchase the property. So in my case, my real estate firm does not hold the earnest money, and the other real estate firm can if they so choose to. But a lot of times what we're seeing in today's industry is we're actually seeing the actual closing attorney hold the earnest money, which is perfectly fine. And if the closing attorney, like Wiseman Law, for example, decides to hold that earnest money, there has to be a form filled out, which is the Form F510, which both the buyer and seller have to agree that the closing attorney is actually holding the earnest money. So let's pretend that Wiseman Law is going to be holding the earnest money in this particular transaction. And then there's actually another Form 511 that the closing attorney has to sign, saying that they're going to agree to hold the earnest money, and then they're going to act in accordance to what our contract says when and if they need to disperse the money back out. So number 7, earnest money should be paid in a check, an ACH, a cash or wire transfer of immediately available funds. And you can have that taken care of at the offer date. You can have it done 3 days after binding agreement date. So all that's negotiable. So the question that was brought to me is, what happens if the buyer writes a check and the check becomes insufficient? What happens then? Or let's say the buyer is supposed to turn in their earnest money to the broker or to the closing attorney, and that has to be done within 3 days of the binding agreement. What happens if that doesn't take place? Well, under page 3 of 9, under section number 6, it simply says, in the event any earnest money check is dishonored by the bank upon which it is drawn, or the earnest money is not timely paid, the holder of the earnest money shall promptly give notice to the same to the buyer and seller. So, if the attorney realizes that, number one, the check has not been turned in properly, or the check came back NSF, non-sufficient funds, the holder of the earnest money needs to notify both the buyer and the seller, and really should notify the buyer's agent and the listing selling agent as well. So what happens then? Oh, well, we've heard the contract automatically terminates, or, we're done. Well, that's not true, guys. So if you read the next couple of sentences, it says at that point, the buyer shall have 3 banking days, not 3 days, 3 banking days from the date of receiving the notice to cure the default. And if the buyer does not do so, check this out, if the buyer doesn't cure the default within the 3 business banking days, the seller may within the next 7 days thereafter terminate this agreement upon notice to the buyer. So the seller just can't say, well, I'm just terminating. It has to be a notice giving. So check's not turned in, or check becomes an SF, holder serves notice. At that point, the buyer has 3 banking days to cure that matter. If the buyer does not cure that matter in the 3 days, then the seller has 7 more days to make a decision as to whether or not they want to terminate or move forward. And it goes on and says, if the seller fails to terminate the agreement timely, the seller's right to terminate based on the default of this said earnest money is then waived. So if you don't take care of that in those 3 days for the buyer and 7 more days for the seller, then the seller is waiving his rights to be able to terminate. And if he goes on the 8th day, he can't just terminate for the heck of it. So this is very important to make sure that we understand what's taking place. Now, I think that, in my honest, humble opinion, both agents ought to be making sure that if the buyer is going to turn in the earnest money to Wiseman Law, which, by the way, Wiseman Law will actually have a particular email where they can go in and set up and pay it through an ACH, and so they don't have to even pay wiring fees. So I thought that was fantastic, and I heard that the other day. But if that's not taking place, you know what? The agents really should be on the phone with in this case, Wiseman Law, making sure that this has been taken care of. And if it hasn't been taken care of, then, you know, we need to do our jobs better to say, hey, Mr. Buyer, you know, time's of the essence. You have to get that earnest money in within 3 days. I'd be saying, Mr. Buyer, are you either ACHing or wiring that money to the law firm on day 2? I wouldn't wait till after 3 days. Or, you know, of course, if the check's given and then it comes back in SF, then that buyer has the right for, you know, curing that situation within the next 3 days, which he should or she should. So earnest money is a serious matter, and the earnest money is good faith that the buyer is going to buy this house. And if the buyer, the day before closing, decides to breach the contract, that earnest money is given over to the seller in lieu of liquidated damages. So that's the essence of earnest money, the importance of it. What happens if the check isn't good, or the check, you know, comes back in SF like I just mentioned, or the buyer just doesn't give the attorney the earnest money? What happens? So that's what that's all about. And you can find that in our purchase and sales agreement, and it spells it out very nicely. So that's my 2 cents today for What's Up Wednesday with James. I hope this has been beneficial to you. And as always, read the contracts. Buyers and sellers, you better be reading the contract before you sign something. Real estate agents, you better read the contract so you know what it says and can answer these questions accordingly, because they're spelled out right there in black and white. There you have it, folks. I certainly appreciate it. It's always a pleasure to come to you. And until next Wednesday, when we have What's Up Wednesday, I look forward to seeing you then. And I hope, again, this always brings you great value and benefits to your everyday real estate endeavors. You have a good one. It's good seeing you guys. Until next week, take care. Thanks again.